Hello, everyone. I'm Kevin Gosztola, and I'm here at the Unauthorized Disclosure podcast for another show, and joined this week by Mohamed Elmaazi, who is a journalist based in London, also with Truth Defense, has done some work for the Dissenter newsletter covering Julian Assange's case, helping me, especially as the court decides to deny access to international journalists who want a video link because it's either too expensive or it would be untenable or difficult for them to make the long trip to London to cover a one-day proceeding. So thank you for being here, Mohamed.
Thank you very much for inviting me, Kevin. Long time, first time.
Yes, yeah, no. I'm glad that we can sit down and discuss what happened this last week with Julian Assange. I don't think we really need to go over the basic details since people who listen to this podcast have heard about Julian Assange's case before. But let's just begin. I'm going to play this clip of Stella Assange so people are clear. There was a hearing that you covered for us, the Dissenter, and that was on May 20th. It involved these assurances, which we'll get in. They're basically promises that were made to the High Court of Justice related to how Julian Assange will be treated. And the decision was, and we'll be getting into this more, that the First Amendment question, the issues around Julian Assange and First Amendment rights in the United States are important enough for an appeal hearing. And so here is Julian Assange's wife, also one of his biggest advocates who's been out there regularly. It's Stella Assange after the proceeding, and she is speaking to everyone gathered about the outcome of the proceedings. So we'll hear from Stella, and then we'll get into our discussion.
The judges reached the right decision. We spent a long time hearing the United States putting lipstick on a pig, but the judges did not buy it. As a family, we're relieved.
Fuck off me!
As a family, we're relieved. But how long can this go on? The United States should read the situation and drop this case now. Now is the moment to do it. Just abandon this shameful attack on journalists, on the press, and the public that has been going on for 14 years.
Free democracy! Free Assange! We love you, Stella!
This case is shameful, and it is taking an enormous toll on Julian. He is under enormous pressure. He has been in Belmarsh prison for over 5 years. It's been 2 years since the order was issued. This case should just be abandoned. The Biden administration should have dropped it from day one. But now is a right moment for the Biden administration to drop it. So please, those in the United States who are in a power to make a decision, please just drop this case now. Don't let this go on any longer. Thank you.
Mohamed, your assessment of what you observed while covering the proceedings at the High Court of Justice on May 20th.
Okay, so it was about a 2-hour trial, a 2-hour hearing, forgive me. It's a permission hearing where you argue your legal grounds and then hope that you'll be granted permission to appeal, at which point you will once again argue those grounds, or at least the grounds which are certified for appeal. And so it did appear to me that, the judges weren't, obviously they weren't fully persuaded by the US government's arguments that its assurances, because the audience may need to be reminded that there were 9 appeal grounds that were put forward. Very serious, very important appeal grounds. The UK-US extradition treaty, for example, prohibits extradition for politically motivated, for political offenses. And they argued that espionage falls into that category, with various case law arguing that. And in fact, the UK-US extradition treaty does prohibit extradition for political offenses. But amazingly, the US government was able to convince the High Court that that's not actually enforceable, because the UK Extradition Act is silent on the matter, which basically means that every single extradition treaty that the UK has negotiated with countries around the world that has a prohibition for extradition for political offenses is meaningless. So I don't know if we have an extradition treaty with the United Arab Emirates, for example, or Thailand, or Saudi Arabia. I mean, the UK has a substantial number of extradition treaties, obviously. And that would mean all these provisions, which exists in, I don't know how many they said, was it 100 or more? I think all but 2 had that provision in there. So, and there were other ones, of course, as well, that he wouldn't get a fair trial. They wanted to introduce fresh evidence about the CIA plot to kidnap and assassinate Julian. And they dismissed all of those but 2 of the grounds. One about the risk of him facing the death penalty, for example, should the charges be amended, and the other one, or 2 others, but they're interrelated, and that's about the arguments that his Article 10 rights, which Article 10 under the European Convention of Human Rights guarantees the right to receive and impart information, freedom of speech, freedom of the press, which is the closest thing that relates in the United States to that is the First Amendment to the Bill of Rights. And that based on statements made by the US itself, earlier in this case, there was a sworn declaration by one of the key prosecutors, Gordon Kromberg, where he was, I think, essentially arguing in favor of their case, saying, oh, Julian is asserting that this case is a threat to freedom of speech. It violates his Article 10 rights. But as a non-US citizen, he wouldn't be entitled to assert First Amendment rights anyway, so that's a moot point. And now that seems to have boomeranged in their face, because the defense has said, look, that's discrimination. That's discrimination based on nationality. He should, whatever the First Amendment protections are, potentially in an Espionage Act case, for a US citizen, he should have the same ones. And in the UK, you would, if you, Kevin, were brought over here to face charges, if a UK citizen were to be able to raise Article 10 rights, freedom of speech, freedom of press arguments in their case here, then you would have the same rights, because they're human rights. They're not citizenship rights. And the extradition treaty with the Extradition Act does prohibit extradition if there is a likelihood of or the risk of prejudice at trial for a number of reasons, and one of them is nationality. So it did. The U.S. sort of leaned heavily, and we can get into this obviously, on 2 main defenses. They're trying to say that the assurances they give were good enough. They seemed actually to lean very heavily, spend a fair amount of time arguing that the High Court was wrong to have even considered that these points were arguable, right? They're saying it's not even arguable that discrimination based on nationality would be a legitimate point for us to consider today. And the judges didn't seem particularly impressed with that, because it's weird. It's like, but it's these same judges, they've already said it's arguable, and let's have some assurances. So they didn't seem particularly impressed with our argument. And then, of course, comes down to the main one, which I assume we're going to discuss, which is the US government trying to argue that, okay, the Extradition Act prohibits extradition if there's prejudice at trial, or the potential for prejudice at trial based on nationality. But what they're saying is he wouldn't have the same rights as a US citizen. So that's prejudice based on citizenship. Nationality and citizenship are 2 different things. So that's a moot point. he'll have decent protections based on his nationality, which seemed a very odd argument, and as the defense argued, has never been presented before.
Craig Murray, former British ambassador, has been chronicling this case, covering it just as much as you and me. And in his writing about the proceedings before the High Court, he starts like this, and our coverage might have picked up on this as well, but I liked how Craig put this. In the normal run of things, if a very senior judge instructs you to give an assurance to their court, it would probably not be wise to avoid giving the assurance, to devote a huge amount of text to trying to obscure the fact you have not given the assurance, and then to lecture the judge on why they were wrong to ask for the assurance in the first place. You were at these proceedings. Does that mesh or match the recollection that you have of how the proceedings were going? Did it appear that James Lewis, the prosecutor who has been the lead for this extradition case representing the United States, did it seem that that's what I get from what you were just saying there, that he's basically standing before these judges and saying they should not be asking for an assurance from the United States?
Yeah, there was a fair bit of focus there. I mean, it was two-pronged. It was first, these assurances are fine, but you shouldn't have been asking for them anyway. But they're fine, and the assurances we've given are fine because there isn't a different. These are two different things: citizenship and nationality. But yes, he did lean into the argument that basically they shouldn't have been asking for them in the first place, because on the face of it, he would have the protections that he would need to have in the United States. And in fact, at one point they were referring to the 14th Amendment, the Equal Protection Clause in the 14th Amendment, which I'd never heard them raise before. In fact, I don't think they have. And the defense also noted that. They said this is the first time. This is a novel argument. You're saying the 14th Amendment would grant for satisfactory protection, would not guarantee that he's not prejudiced at trial. Like, we haven't heard this before. There's no authority. You haven't provided, any expert testimony for this or expert evidence. So they also pointed to that and said, look, even if there is an argument to be had there, and we say there isn't, we can't flesh this out right now in a permission hearing. That's all the more reason you have to grant an appeal, so that they can flesh out these 14th Amendment and other arguments in more detail, and that we can respond to them. So that pretty much sort of guaranteed, if you like, if you're going to start presenting novel arguments, and this is only a 2-hour permission hearing, then they're going to have to spread it out. They're going to have to have an actual appeal hearing to deal with it in more detail. And it is an interesting one, because the judges in their March decision, when they rejected, like I said, most of the 9 grounds of appeal that Julian's lawyers put forward, they did seem genuinely concerned, both in their judgment, but even during the hearings in February, which we also wrote about at the time. The ones that they asked questions about the most was about the death penalty, the risk of death penalty, and about the risk of prejudice at trial based on citizenship. They almost seemed surprised, actually, which is fair enough, because until Gordon Kromberg had made that declaration, or even Mike Pompeo had argued that, I'd never heard anyone argue that before, that a non-U.S. citizen for speech they've given outside can't assert First Amendment protections inside the United States, even though it appears there is actually case law to back that up, although not in an Espionage Act case prosecuting a publisher, because that's never happened before. Like, this is an unprecedented case. So there's so much that is up in the air, but it means it's a very real possibility. So the fact that they thought that this incredibly serious concern, James Lewis thought that this incredibly serious concern was not worth the judge's time. And he, obviously you don't rebuke the judges deciding your case, but he did lean into it heavily. And perhaps it's because they realized they got themselves in a bind, right? Because now they're realizing, oh, the judges are taking this discrimination ground seriously, well, what can we say now, right? They're dealing with their American clients. James Lewis is a UK barrister, but his clients are the US Department of Justice. And they're telling him, well, look, we can't, it's up to the judges in the United States. And in fact, there is case law to say that he would be discriminated against and not granted First Amendment protections. So now you've got to think to yourself, okay, well, what are we going to argue? You're going to have to come up with something. And one of the things they come up with is, well, 14th Amendment, Equal Protection Clause, nationality and citizenship are two different things. The Extradition Act doesn't prohibit prejudice at trial based on citizenship. It prohibits prejudice on trial based on nationality, as though somehow that when Parliament drafted the act, they thought like prejudice based on citizenship, that's fine. It's just the nationality point that we care about. And lots of people, you know, for most people, or for maybe hundreds of millions of people, nationality and citizenship are the same thing.
You're talking about the novelty of all of this, and it is worth saying that that issue was rejected by the High Court of Justice because it was pointed out by Assange's lawyers that Article 7 of the European Convention on Human Rights says that extradition is not supposed to extend to anyone who, in this instance, it's the United States government, if they're seeking to find guilty of a criminal offense that has not been a criminal offense under national or international law at the time when it was committed. And in the US, we have all of this evidence before us, and maybe it's just executive branch discretion and a choice that they've never pursued a case against somebody, but that still exists as evidence for a court to review. And there's never been a full consideration. Well, you could say that Vanessa Barretzer did as a district judge, but upon appeal, it certainly would be a fair argument for the High Court to go over whether the district judge had given this enough attention. It seems like it might be worthy since there are important issues and stakes involved. Of course, that's not where we are right now. We're talking about Article 10. And I think the benefit that you bring to our show is that you are someone who understands the UK judicial system, or you've considered the European human rights conventions. And I'd like to just ask you to help people understand the way that the First Amendment issue fits into the question of Julian Assange's right to freedom of expression. Because the thing of it is that the Freedom of Expression Convention is actually more broad than the First Amendment, in that it's not linked to anything that you would gain as like constitutional rights from being a citizen, correct?
So that's correct. So it's one of those things where, and I can't recall, I think we might have been discussing this previously off camera, not today, but previously, that at the end of the day, or that might have actually been with Chip Gibbons, I can't even recall now, you know, bills of rights, European conventions, things like that, you know, laws or constitutions which provide individual freedoms, they provide you the freedoms that courts interpret them as providing you, right? In the sense that if a court decides that people can be prosecuted legitimately for a certain thing, and they interpret the Constitution a particular way, then that's what the Constitution says, because at the end of the day, what matters is what those who hold power say the law says, in a sense, right? I mean, you're arguing these things before judges. So there will be parts, the First Amendment at times will be more protective, certainly, than Article 10 is interpreted in various European countries that have the convention incorporated into law, and other times less. And this would be one of those examples where, because it's the European Convention of Human Rights, right? It's not the European Convention of Citizenship Rights. It, by definition, would grant any human being the same, you know, freedom of speech or due process rights that a citizen would have in the same circumstances. Obviously, for example, non-citizens can't necessarily vote. Well, actually, residents in the UK can often vote in local elections, right? I don't know if that exists in different parts of the United States as well. I was actually surprised. I wasn't aware of that previously. But when it comes to like due process rights or free speech rights, if you're, I don't know, even a tourist and you're here and you're charged with something that a UK citizen or UK resident would at least be able to assert at Article 10, First Amendment protection, then you too would be able to assert that. It doesn't mean you'll win on it, right? But you're at least able to assert it. And in this case, it looks like we don't have any case law directly addressing, the extradition, the Espionage Act being used against a publisher. So what we have are like other types of cases where, where people have been prosecuted and they've asserted in the United States for actions they were linked to abroad, and they've asserted, at least as part of their defense, a First Amendment ground argument. And the US courts have said, well, you're not a US citizen, you're not a US person. You can't assert First Amendment protections, at least in cases where national security is implied. So that's the interesting thing, is like you're a foreign citizen, your speech or your actions were on foreign soil, and there's a national security implication that's alleged, then you're denied First Amendment protections, even if a US citizen in the exact same situation would be granted First Amendment protection. So that's blatant discrimination. That means I have less protections for stuff I said and did outside of the United States than a US citizen would. And that is not the case with the European Convention of Human Rights, based on, case law and the fact that it is a human rights convention.
And then let me draw attention to one more line that came from the prosecution, and it was highlighted over at TruthDig by someone who's been very supportive of my work and also as engaged in the Assange case as me, and that's Stephen Rohde, who has been was involved in the ACLU, is a longtime civil liberties attorney, and now publishes an ongoing series on Assange for TruthDig. And I'm just going to read this for you, and then you can give me your response to it, because I know you probably didn't gloss over this line. I'm sure it meant a lot to you given the stakes of this case for journalism around the world. James Lewis, KC, for the prosecution, refused to back away from Kronberg's claim that U.S. could argue that foreign nationals are not entitled to protection under the First Amendment, at least as it concerns national defense information. In fact, Lewis went even further in an official statement that should terrify U.S. journalists. No one, neither U.S. citizens nor foreign citizens, are entitled to rely on the First Amendment in relation to publication of illegally obtained national defense information that poses a threat to national security. Lewis cited the giving the names of innocent sources, but there's no evidence Assange did so. In fact, U.S. officials have testified that they know of no person who was put at risk by the WikiLeaks revelations. So that just encapsulates what James Lewis was saying there. Now, what are your thoughts on this? Because that was part of what they were trying to persuade the High Court in not granting an appeal hearing.
Yeah, that's true. So that was, there are multiple critiques that the defense put forward in terms of the U.S. assurances argument. They said, well, one, they could have, at the very least, have said, okay, we agree to be bound. We absolutely promise and guarantee that the U.S. Department of Justice will not at any point in time in trial or pre-trial argue that Julian Assange does not have First Amendment protections. I mean, they could have done that, right? And while that wouldn't have addressed what the judge decides, because obviously the judge will make their own decision, at the very least, they could have recognized the High Court have made clear this is a concern, this potential prejudice. So we just won't argue that that Julian isn't entitled to at least assert First Amendment protections. And they didn't even bother doing that. Yeah, there is also the frightening aspect that, yes, of course, it is being argued that the First Amendment doesn't apply to anybody under the Espionage Act. I mean, they're trying to say innocent people, etc., put at risk. But let's be clear, as the expert testimony that the high court judges heard from a former U.S. federal judge that is now a professor, that was cited and relied upon by the defense, they made clear that actually, under these circumstances, you would expect a U.S. citizen to be able to rely on First Amendment protections, to rely on them. It doesn't mean you'll win, but to at least assert it at trial. And unlike what the US government was arguing, you should be able to rely on them in relation to all 18 of the charges. So the fact that it is being alleged that some of the disclosures had names of sources, right? U.S. government sources. In three of the charges, they pertain to disclosures which they allege had names of people who could have come to harm, etc. The expert evidence of the former federal judge, now Professor Grimm, that's his last name, Professor Grimm, was that you would be able to assert it in all of them. And presumably there might be some kind of balancing test. Because let's not forget, just because the US government says something doesn't mean it's true. Just because they say you've revealed the names of innocent sources doesn't mean that, like, oh, well, we've asserted it. So judge, he can't argue First Amendment grounds on that, or American lawyer, American journalist, publisher can't assert First Amendment grounds because we're saying that they revealed the identities of sources in some of these releases, which pertain to only 3 of the grounds. So, surely you would have the opportunity to challenge even that part of the argument. So it is disturbing, but like we said before, this case has never occurred before, right? There has never been a prosecution of a publisher or a journalist under the First Amendment. There was an attempt in the Second World War that I think I'm aware. I can't recall if it was against the New York Times, but it didn't even go beyond the indictment level. It lost. The grand jury didn't even issue a return with an indictment, and that is the only even attempt that I'm aware of, let alone a grand jury returning with an indictment.
Yeah, I believe Carrie Shankman, who's done a fantastic book, Century of Repression, on the Espionage Act, and he highlighted several examples, and he was also a defense witness at the extradition hearing in September 2020. And he's mentioned James Bamford, who's a journalist covering the NSA, that's Seymour Hersh. Both of them were threatened at some point with prosecution. There's a small outfit called the Beacon Press. They wanted to actually publish the Pentagon Papers as a book and were threatened by the Nixon administration as they tried to pursue that publication.
Mm-hmm.
Never got to this point. And, it's also just worth making sure that we are clear. There's no law in the United States for the average citizen against the publication of the names of sources.
Yeah, exactly.
And especially if there's no intent. Like, if I don't have an intention to out that person and deprive them of a job and make it so that they could never work in government again, which I don't think that was Julian Assange's reasoning. It wasn't. It was always because the data set, in order to be complete, needed to include their names. And that's a fact that,
it had already been released. It had already been released by Cryptome, right?
Sure, exactly. So the other issue is that when they talk about these human sources that are allegedly named, that information was already accessible on the internet.
Yeah, and it was already accessible. It was accessible on a website which technology expert testimony in the original hearing had already presented. There was a guy who was able to do all this analysis based on search results in Google back at the time, and to show that Cryptome was a much more widely known website, much more likely for organic traffic, that is to say, search results in internet search engines to end up there. And so then there's a question of, okay, so it's already out there. Julian had contacted the State Department months before. We have a 1-hour recorded phone call of him with the State Department saying, okay, through no fault of our own, there are people now trying to gain access to the unredacted cables because let's not forget, two Guardian journalists, David Lee and Luke Harding, published a book where, thinking they're very clever, they published the full password. I can't remember how many characters it was. It wasn't even a password, right? It's just random characters, like 13, 14, maybe more than that, 16, to the complete unredacted cables. Now, people didn't know, they didn't say what it was, but once some people are able to figure out that you have these highly encrypted files that are available online that would take, I don't know, a supercomputer 100 years to break through brute force. But if you have the key, the 17 characters, you can unlock it like that. And when Julian finds out that, like, oh my God, what do these idiots do? After for months, they're begging me, demanding this password, and I'm telling them how important it is that this is kept secret. So he finds out that this is on the verge of becoming released. He contacts the U.S. State Department and he tells them that the full unredacted cable is on the verge of being published, and they do nothing about it. So this whole idea that they really care. Let's not forget, Cryptome are based in the United States. They could have prosecuted or complained about Cryptome, and they didn't. And in the end, a decision had to be made about whether or not to now release the unredacted cables by WikiLeaks to ensure that there's no kind of falsification, editorialization, etc. I mean, there was a, you know, we can dispute whether or not we think that he should have done it, but the point is it was already out there by a website that had far greater reach, and the US State Department could have acted to prevent it, and they chose to do nothing. And we have the recording. Anyone can go on Assange's defense and go and find that, the phone call to the State Department. So there's so many issues with this case. And you know, and that's one of them. And I think you, of course, have mentioned many times the Obama administration. And in fact, I was on a Twitter, I don't know what's called, Twitter chats, Twitter call, Spaces, yeah,
format,
yeah, where there's a journalist there, an American journalist, who made clear, he said he spoke to US DOJ officials, including Attorney General Holder, who told him that not only, you know, that the New York Times problem, that the Obama administration, when they were trying to look at whether they could use the Espionage Act against Assange, they're like, what they called the New York Times problem. How do we go after Assange without going after, opening the door of the state going after the New York Times? Which of course shows their thinking. They're like, an establishment news outlet, this would be an issue. And in fact, he said he thinks this Attorney General Holder, who told him that it's not just a New York Times, it's all journalists in the press corps that would be at risk. So this is a Trump administration decision under Pompeo, and I think we all know, at least according to the Yahoo News article, but this jives with what the whistleblowers from UC Global, the security firm that was surveilling the embassy, what they also said is that after the Vault 7 leaks, that's when the CIA really decided to like redouble their efforts and put a lot of pressure that we've got to get this guy. So if we got a chance at some point, I'd like to read some of the responses in the defense submissions to the assurances, because the assurances, not only do they not promise that the US government won't argue that he doesn't have these rights. So they could have said, well, we'll keep our mouth shut, right? But that still wouldn't deal with the other issue, which is what the US government admitted, that it's up to the judges, right? That there's separation of powers. There is case law that could run against Julian, and ultimately we cannot issue a binding assurance to say that Julian Assange can rely on the First Amendment, because we cannot bind the courts in this case. This is something that is a matter of judicial discretion, right? Which is why I think they really leaned in the argument that the First Amendment doesn't apply for citizens, and they think the judges shouldn't have even allowed, you know, this hearing to go ahead. And there's a great line here from the defense, right? Because what the government said was, the U.S. government, and their assurance, their non-assurance assurance, right? Their toothless assurance, as we said in the article. Assange will have the ability to raise and seek to rely upon at trial and at any sentencing hearing the rights and protections given under the First Amendment of the Constitution of the United States. So he may raise and seek to rely on. And what they point out, they say the ability to seek to rely upon the First Amendment means nothing. Any defendant whose counsel can open their mouth can raise and seek to rely upon the First Amendment. Again, the court cannot, and the US court will not, liberally interpret the carefully chosen words of the assurance, what we're putting in square quotes. So I quite like that, right? Any lawyer that can open their mouth can seek to rely on the Constitution in any case, in any circumstance, anything you can seek to. You can say, hey, the moon is made out of blue cheese, right? Like it doesn't matter. The issue and what the high court judges demanded, they demanded it, right? Right? They instructed, they said, we will grant an appeal unless the US government grants assurances that A, he won't face the death penalty, and they did, and the defense have accepted those assurances, and B, that he will not be prejudiced based on his nationality, and that he'll have the protections equal to that of a US citizen. And now they've come back with this.
It's an incompatibility, basically, that you have in the UK right now, an extradition law, or under extradition law, that you can't have prejudice based on your nationality. You can't extradite somebody to a trial where they would be prejudiced. And so then the US, through these prosecutors, has to be able to demonstrate that the prejudice won't happen in the US. But if you look at First Amendment case law, as is being pointed to, you now see very clear examples of how Julian Assange will be treated differently because he is not a US citizen. And so that's something that the US has to figure out and untangle. And that is why I believe Craig Murray had a fairly upbeat reaction to the High Court granting an appeal. So let's go ahead and watch this.
Today, the whole thing has come down to a single point. And it's a terrible injustice that it has, because a great many extremely important points have been dispensed with by the court. But today, there's only one point at issue, and that's whether the assurance which the United States government was asked for on Julian Assange's right to First Amendment protection will be given. And that assurance was specifically an assurance that his right to claim First Amendment protection would not be barred solely on the grounds of his nationality.
Right.
And that assurance has not been given. And what the United States have said is that he will be able to argue in court that his right to First Amendment protection should not be debarred on grounds of nationality.
I think the words that he can seek, right? And Stella Assange is Julian's wife. What she called it, weasel words, correct?
It is, but it's very obviously weasel words.
Yeah.
And what the United States have tried to do is they've tried to conflate two things. The court did not ask for an assurance that the First Amendment argument will prevail over the national security argument, for example. They didn't ask for that assurance. They only asked for an assurance that the First Amendment would not be ruled out on grounds of nationality alone.
Right.
And the American assurance doesn't even address that point at all.
Yeah.
It merely says he can seek First Amendment protection. So if the court has any self-respect whatsoever, or any intellectual integrity, they have to see that that does not meet their demand.
Right.
Yeah.
And this is a demand which the court has made and said this assurance must be given for this extradition to proceed. And plainly the assurance hasn't been given. So I'm actually hopeful today. I've never turned up hopeful before, but the humiliation the court is going to have to go through if, having insisted on an assurance and not gotten it, it nevertheless backs down and orders the extradition, is going to be extraordinary.
State of free press in the UK, from time to time, not only have you helped the Dissenter by covering the Assange case, but you've also written about these national security bills that have come up for a vote. We've seen I guess the point that I want to really cover as we end is how there's been this parallel erosion of civil liberties in the UK while Assange has been languishing in prison with efforts to crack down on protests, make it harder for people to demonstrate.
Yeah, that's right. So there have been multiple anti-protest laws. Of course, they don't call them that. They call them police and crime bills, things like that, to make it easier and easier for police to arrest people and for people to be prosecuted for demonstrations. Although there was a change in the law that was recently found to have been unlawful, that the Home Secretary had unlawfully reduced the threshold through which you could be detained and arrested to so low. So like any minor inconvenience, right, to traffic or minor inconvenience to the public could lead to an arrest. And thankfully, the High Court found against that, not because if it was primary legislation, unfortunately they wouldn't be able to do so, right? It's in the UK, judges cannot strike down legislation for being unconstitutional. We have the National Security Act, which passed, which, you know, increases the likelihood now, like journalists could face life in prison if they publish information without authorization. And in fact, during the debates in Parliament, even though this is supposedly about protecting the UK from a hostile foreign power, right? As part of the debates, WikiLeaks was being raised, and they made all kinds of allegations there about harm being done and national security being impacted, which were just completely false.
All right. Well, Mohamed, it's really great to have you here on the show, and I'm glad that we were able to spend the time with this discussion. And there's still a lot more that is unresolved. So I imagine you'll be back again in the next months to discuss what has been happening. But for right now, why don't you tell people where they can find your work? And then also, I know that you're involved in Truth Defense. If you want to tell people a little bit about that before we go, you're welcome to do that.
Right. So it's something Truth Defense is a website I took over a little bit ago, but you know, I'm doing my best to sort of get as much resources that can allow me to do the kind of reporting that I've done with the Dissenter. I mean, obviously the Dissenter pays me, but a lot of the work I do requires unpaid sort of research, like for the work that I published at Declassified UK. That's one outlet I published with, as well as Electronic Intifada and Consortium News. I had an article based on archival research that revealed for the very first time that the UK had an explicit formal policy and engage in sort of propaganda. And they called it like political propaganda attacks and political attacks of the left-wing government of Kwame Nkrumah in Ghana in order to create an atmosphere that would lead to the overthrow of the government and being replaced with a more Western-friendly government. And I found a document with an explicit quote there. So it's that kind of things. I cover matters related, like you said, to national security, freedom of speech, the attacks on the ability for people to express dissenting views. Truth Defense came into existence before I came on board, came into existence because of the smears, the false anti-Semitism smears that emerged when Jeremy Corbyn was leader, and people were being accused of being anti-Semites because they were critical of the state of Israel or because they're supportive of Jeremy Corbyn, and it was targeted disproportionately against Jewish members of the Labour Party who have been purged from the Labour Party. Ironically, that's not anti-Semitism because they're the wrong kind of Jew, as some of them explained, right? They're left-wing or they're critical of Zionism, or they're not ethno-nationalists, right? So if people are interested in supporting me, if they want to see my work, I've already said where you can go, including, of course, at the Dissenter. If they're interested in supporting me, please consider making even small donation or recurring payment via truthdefense.org/join. That is what the URL was before. I wish I could change that to donate. But and it's Truth Defense spelt with a C because it's the United Kingdom, and that's how they spell defense over here. So truthdefense.org/join if you'd like to contribute a bit of money, help me do more of this work. Oh, there it is.
The banner up there, just out of courtesy to you coming on the
Thank
show,
you.
Spending your time. And that's the URL that you just gave. So
cool.
Thanks everyone for tuning into the show. I'll be back next week, and we'll keep this thing going. Thanks everybody.